Call the Tuesday, August 5th, 2025 meeting of the Westminster Board of Zoning Appeals meeting to order. With that, we'll start off with introductions. Scott Braff, Chair of Westminster BZA.
Richard Huss, Assistant Chair.
Peter Basile, Member, BZA.
Karen Roth, Board Attorney.
Mark Depot, the Director of Community Planning and Development for the city.
Joe Atkins, Planner.
With that, we have the approval of meeting minutes from June 3rd, 2025. For a continuation of that, there are some amendments to that need to be made.
Yes, sir.
So we will hold off on that till a later month. And with that, we have the approval of final decision letter, BZA, case 25-03. Couple of months back. Had a chance to review that comment. Fine with how it was written. For shorter signature. I'll move for approval the final decision letter of BZA 25-0.
Second.
Motion's been made and seconded. All those in favor? Aye. We have a public hearing this evening with regard to case number 25-04. This is an appeal of the zoning administrator's determination. We want to do that first, I guess. Well, let me read what this is reference to first. An application by Modular Genius Incorporated to the applicant and the property owner for an appeal of the May 21st, 2025 zoning determination made by the zoning administrator concerning if outdoor storage would be permitted use in the Meadow Branch Industrial Park, Lot 2C, Westminster.
The question. It says April 21st, 2025 in the whole print and May 21, 2025 in the description. Yeah. Which is it?
I'm sorry, it's May 21st, 2025 was the date of zoning bill CBET 2504.
Was that the date of the appeal or the date of the zoning determination?
The actual determination, the date of the appeal was April 4th, 2025.
You sure it's April 4th?
April 4th, 2025 is when the appeal was requested. I'm sorry, when the zoning determination was requested, the zoning determination was made and provided on May 21st, 2025.
And the date of the appeal?
The date of the appeal was June 20th, 2025.
Thank you. There was a motion for postponement of the appeal that was filed by the appellant applicant. I think we need to hear that first.
It's a preliminary matter that you should dispose of, so you would hear from the appellant as to their motion initially.
We need to swear in with regard to that or not, so we can.
No, you don't need to swear them in.
That will work me out.
Thank you. Just stand here, okay?
That's fine.
Okay, thank you, Mr. Chairman, members of the board. My name is Adam Rosenblatt. I'm an attorney for the petitioner in this case, Modular Genius. With me is Damon Pross, who is the owner operator of Modular Genius. As you said, on April 4th, a zoning determination request was filed on behalf of the petitioner seeking a determination of whether a use as described in a letter was permitted on the subject property, which is zoned IR. On May 21st, a response was written by Mr. Depot saying that the proposed use, which was described essentially as an outdoor storage lot, is not permitted in the IR zone. And an appeal was filed to preserve that issue. Now, subsequent to filing this appeal, the petitioner has pretty substantially changed their proposed operations for this site. They were planning to, in the future, construct a building, and they were planning to limit the use of the property to essentially outdoor storage, which is what the zoning request letter stated. The proposed use now includes the construction of a building from the start, some assembly, light manufacturing, and job creation elements that we intend to discuss and to prepare a revised zoning determination request that we would send in to Mr. Depot. The reason we did not simply dismiss this appeal and this request for zoning determination is because we feared that it would create a legal issue, potentially a res judicata or estoppel issue, and postponing this proceeding to give us an opportunity to properly describe the use that is now proposed on this property and to get a determination from Mr. Depot as to whether the proposed use is permitted on the property would remove that legal issue. We do believe that the proposed use, as we will describe it in a subsequent request, is substantially different from the use that was described in the initial letter that led to this appeal. So we do believe that we will get around any issue of res judicata or estoppel, but it does simplify and remove a potential legal issue if this case is placed on hold so that there is not a final zoning determination and the merits of the revised request can be reviewed just that way on the merits without any fear of legal issue complicating. I do apologize that this request is filed so close to this hearing, that people took time, neighbors to this proposed use took time to be here. I did reach out in middle of July, on July 18th, spoke with Mr. Atkins and indicated the petitioner planned to ask for a postponement, but Mr. Atkins understandably relayed that this hearing had already been advertised in the local newspaper and that people, as we see, neighbors may take an interest in this, may have shown up tonight, and if it was simply postponed prior to this hearing, that there was no way to inform anybody that planned to be here or planned to participate online. So I believed that the only way to make this request was to make it orally at the outset of the hearing. But after discussing the issues with counsel for the city last week, I decided that it was in the best interest of everyone if I made this request in writing. Even though it's so close to the hearing, it would give you an opportunity to see the justification for this request, which is, as I said, based on a change in the proposed use and in the interest of removing the res judicata or estoppel issue from a revised request that we will file. So I thought it would just be clearer for everyone if the request was in writing, so you had a written summary of what I intended to say, and I'm saying now tonight. If this hearing is postponed, we will issue or draft a revised zoning determination request and get a decision one way or another on whether the revised proposed use of this property is permitted. And depending on the outcome of that, we're hopeful that it will either be a use that's permitted by right or by special exception. So you may see us in the future at a special exception hearing if that's the determination of Mr. Depot. If the determination is even based on the revised description of the use that it is not permitted on this property, then we have a decision to make whether we appeal any subsequent determination or whether we just look elsewhere. But under no circumstances can we proceed under the appeal that's before the board tonight, because the letter that led to the determination does not properly describe the use. So we're appealing something that no longer applies to our proposal for this property. And that's why we're asking for a postponement. Again, I appreciate everyone being here. I'm sorry you had to be here just to hear me ask for a postponement, but Thank you for hearing.
There's questions of the applicant representatives regarding the revised motion for postponement.
I'd like to know if there are any questions from people who appeared here for the hearing. Anybody who's here objects to the postponement. Ultimately, it's a decision of the chairman of the board.
Mr. Chair, I believe that the city, by way of either staff or the city attorney, wanted to address you before you made.
Okay, so I was gonna ask that.
I can go first, that's okay. And this time the city does not support the postponement of the request. We do not believe that as described, it meets the requirements of extreme hardship or good cause. In the postponement itself, it references that they are proposing something completely different. We don't have facts about what's being proposed. I can't say that a determination would be equal to the one before you today with this new request. I don't think that's a proper avenue to go through. I think the Board of Zoning Appeals should hear this request tonight as requested for appeal by the appellant. I'll let the city attorney, unless you have questions of me.
So if we were to proceed this evening with hearing it as it was originally presented, and let's just say it's tonight, they would be free to come back with another request at a later date, correct?
Exactly. There's nothing that's stopping them from submitting. They received back in May 21st, 2025, the determination. They've had that time to submit a new zoning determination request. They could have certainly asked for that to be reconsidered. They have submitted a special exception application. It just hasn't met the requirements needed for all the elements provided to be accepted. So they've had plenty of time to submit that other zoning determination request. I just don't think it seems proper to postpone this case at this time, and we're requesting that it move forward.
Mr. Chairman, if I could be heard. Good evening, members of the board. My name is Ramsey Whitworth, the new city attorney for Mayor and County Council of Westminster. To try to help maybe solidify what the issue is for you to decide. I think we're all in violent agreement that the appeal that is before you presents facts that were submitted to Mr. Depot as the zoning administrator to determine that have substantially changed since they were submitted to him. I don't want to speak for Mr. Rosenblatt, but I would think that some of what's being stated here is that the facts that were presented to Mr. Depot for his determination, as he reviewed them, were accurate. He made a proper determination that they do not satisfy a permitted use under the zoning ordinance. And the facts have changed, and the applicant is intending to use the space in a different way, a way that may in fact fall within a permitted use, but we don't know that yet. And so I agree with Mr. Rosenblatt to the extent that the facts have changed substantially. It may not serve the interest of judicial economy or this board's economy to make a decision one way or the other on the appeal. The concern from the city's perspective is one really of precedent, that if we were to allow a procedure in which an applicant is able to submit an application based on a certain set of facts, the zoning administrator relies upon the representation of those facts to make a decision. The decision is against the applicant appeals, and then it prepares or intends to file a new request for zoning administrative decision termination, come in and ask you all to just hold this appeal in limbo pending the filing of that application, which may or may not have substantially different facts. And then if it goes against them, we're in a procedural sort of dilemma that the zoning ordinance doesn't contemplate keeping appeals open indefinitely so that the applicant can come and refile and resubmit under potentially different facts. And then if that gets denied, we come back to you with two different issues for you to review. The first one that we're here for today, and then the second one that's been denied. So candidly, I think I don't criticize Mr. Rosenblatt for what we call as an abundance of caution, right? But if the facts are substantially changed, then there's not really any, the appeal should be, the decision of the zoning administration should be affirmed. And we should then potentially come back here or not after the resubmission, hopefully not. Hopefully there's gonna be a resubmission with new facts. And those facts are such that the zoning administrator can determine that they do in fact fall within either a permitted use or a special exception. We never have to be here again. But we're just concerned about creating a precedent that puts us in a limbo that might be used improperly in the future by other applicants. And that's really our concern. We want to support having the use be used in the way in which the zoning ordinance states, and hope that the applicant's able to do that. We're concerned allow for a postponement of these circumstances. Standard is under 164, 168 good cause. I don't believe that this would satisfy.
So where do we stand then between a denial and like a cease and desist operations type? Is that like immediate, or where would that fall? Like if we were
The postponement request?
no, if we were to move forward with hearing it and then say that your opinion is correct, and I guess an appeal could be filed, and they could
appeal
operate under that for.
They could appeal your decision. However, there is no approved use or operation at this point. They still have to go through other processes for an allowed use. The facts are changing and that use was therefore allowed. If it's a permitted use, you have a site plan, special exception use, it's back before the Board of Zoning Appeals, make the decision to approve or deny the special exception use. So it doesn't stop the applicant from submitting a new zoning determination request or from filing the proper development plan application.
What's your recommendation, Mr. Wu? What are you asking the board to do?
If I were on the board, I guess I'll put it that way, right? Which is to say, I think the proper procedural determination would be that we allow Mr. Rosenblatt to do exactly what it is that he's and the applicant to do exactly what it is that they are telling us they're going to do. And for us as a city to support them in doing that, which is to file a new request for zoning determination based upon the facts as they now exist. As it relates to this board, my preference would be that if that's going to be what we're going to do, then the applicant will withdraw the appeal and we then focus on that procedure. I'm not giving any legal advice here, Mr. Rosenblatt's an excellent attorney and an excellent firm. If, as they suggest, the facts are, quote, substantially different, then my understanding of res judicata in a circumstance such as this is that there would not be res judicata because the facts have substantially changed. So therefore, the out of abundance of caution concern for why we're here today shouldn't exist so long as the facts are actually different. And I trust Mr. Rosenblatt, I certainly trust his client that if that's the representation that they're making, they're going to be different. We just don't know yet because we haven't seen them.
Right, Mr. Rosenblatt, that was my impression, having read the case of Seminary Galleria
Yes.
that you cited. And I do think maybe you're being a little bit too cautious in addressing the issue of res judicata here. If the facts end up being what are represented here, it sounds to me like a completely different use than the one that was proposed with the initial application. Is outdoor storage, will that be part of the new plan?
Yes, there'll still be, that's why we say an abundance of caution, but it will include a building, there will be work inside the building, there will be these modular units will be stored on the lot as part of the use. It will not be an outdoor storage only use, which is what was described in the letter. But given that I agree with what both of you are saying. But it just takes the legal issue out of the equation if this is held and postponed rather than determined tonight. And to be clear, we cannot go forward tonight because I cannot advocate for what was described in that letter. So if it's not postponed, there's nothing for us to do further. We would withdraw the appeal if that's the determination.
Well, that, you know, again, that's my concern is with postponing it indefinitely, pending a completely new process seems to set a bad precedent, I think, for future appeals. And I mean, the Seminary Galleria case says that, you know, whether an agency's declaration should be given preclusive effect hinges on three factors: whether we are acting in a judicial capacity, whether the issue presented was actually litigated before the agency, and whether the resolution was necessary to the agency's decision. Seems to me if you withdraw the appeal, none of that happened. Again, I'm not making a determination, so to speak, on the issue of res judicata. But it seems that the better way to approach this is to simply dismiss the appeal. And certainly say that you're dismissing it without prejudice. And it seems to me like the new application appears to be a completely different use than the one that's being proposed here. And maybe it has a tangential aspect of the use as opposed to being an outdoor storage lot, and that may receive a different reading from Mr. Depot's office. So that's what I have to say. I mean, if you have anything that you'd like to.
Yeah, I definitely understand what you're saying. Even the fact that we have come here to hear that is the interpretation of a member of the board is helpful, as opposed to if I had just withdrawn this appeal. I'm sorry everyone had to come in that, but if I had just withdrawn it and we hadn't had this discussion on the record here, I think we're in a worse position than we now are, even if you deny the postponement request. So I appreciate that analysis. In terms of creating precedent, these type of cases are really all that I do. I have never seen this before. I've never seen where a proposal is described and then there's an appeal, but the use changes. It's a very unique set of circumstances. So I just don't know that this would ever come up again. I understand that you don't want this to be sort of something that could be weaponized by a future applicant, and that is absolutely not our intent. And I think that everyone knows that, but I understand the fear of creating precedent, but this is just such a unique situation that I can't see that it comes into play very often.
The larger concern will be going forward with the appeal, having us rule on the issue.
And we don't intend to do that.
If there is a withdrawal of this, we need to act.
Yes, I didn't hear him say that. I think I heard say if you do not grant the motion, that he may be in a position to withdraw the appeal.
So we have to make a decision on the motion that's pending, which is whether to grant the postponement or not. And if not, then I think we'll probably hear again.
Do I hear a motion on what's before us, the revised motion for postponement?
In terms of I would move that we deny the motion for postponement.
Motion's been denied postponement.
Second.
Motion been made and seconded. All those in favor of denying the revised motion for postponement, say aye.
Aye.
We will have a very quick meeting tonight because we are going to follow your advice and withdraw this appeal and re-describe the use and be in contact with Mr. Depot with hopefully a different outcome.
Appreciate it. Thank you for coming.
Thank you all for your time.
Thank you. Thank you. Appreciate your time. Any other business by members of the board, staff? Or council?
None.
I'm not sure, I will say that we do not have any applications for September. So we will not have September since they withdrew the application.
Hearing no other business, I'll entertain a motion to adjourn.
I'll move for adjournment.
Seconds. Made second, all those in favor?
Aye.
Aye. Thank you, John.
Thank you. Thank you very much.
I'm actually. That's.
I'll be nice.
Sorry.
They really just wanted.
That's okay. I guess I'm all out there.
Maybe saving 10.
He says,